document and we individually read it so that we can understand what's in it. I mean, look, I think what we were presented was that the data is revealing, but what about the next work product? And at what point do we stop work product releases to protect the community from long-term things, mindful that we haven't completed our portion of the settlement? And that worries me. It really worries me. I hear where you're coming from. As I said, I'm constitutionally set to share everything. But what else is in the work product that we're going to then talk about in November and then something in December? And I don't want to blow that up because I don't know what those are, but I don't know what those are. And I think there is a point where in service of releasing data, we're going to damage, I have no idea what we could theoretically damage future legal issues that we have related to this whole thing from either side.
I clearly I sense why you're troubled by this, and I think that it's a tough balance here that you're all struggling with, because I think that you genuinely would like to, if at all possible, err on the side of disclosure and allow for dialogue. I think that the part of the problem on the other side of that is that the mock jury exercise is an extremely nuanced sort of thing, and so it's not all that easy to understand out of context. And what we are talking about here is about as classic a case of Monday morning quarterbacking as you will ever experience, because you have to have been a litigant in litigation, and you have to be in that situation where you are faced with a trial and where you are consulting with your attorneys and you are being provided with a lot of information. It's extremely complicated, and you are being advised of the strengths of your case, the weaknesses of your case, the risks associated with the case. The mock jury exercise was just one small piece of information. It was not by any stretch the driving consideration. It itself, is an imperfect tool. You hired expert lawyers who were there to advise you and to assist you in the litigation, and you're at a point where you have to make a decision as to what's in the best interests of this community in the long term. And it's very difficult if you weren't in that room, and you were, hearing all of the advice, having all of the information, and faced with the imminent trial, to truly understand being in that situation. There are many people in this community who have been in that situation, who have been litigants or who are attorneys and who advise clients in litigation, who understand this process. And so I'm not saying anything that's mysterious or secret or anything all that novel. But what I am suggesting is that it's a very difficult decision to second guess. It's no different than Monday morning quarterbacking. You can second guess that coach all day long on Monday morning, but when that coach is there making that decision of which quarterback to use or which play to run, that's the moment, and that's a difficult moment to second guess a day or two later. It's easy to second guess it in some respects, but it's also very difficult because you don't have all the information. So, I leave you with that. You can certainly put it on the agenda. You can certainly consider the pros and cons and do what you think is best. I don't think that a tragedy will befall the community if information is released.